Ladies and gentlemen, our jury has reached a verdict. You have seen the TV camera taking the images in the outer part of the courtroom, and that was at my direction. If there is any outward bursts or anything else like this and any disruption to this court, as you can see, my sheriffs are around the inner part of the courtroom. You will be arrested immediately and taken into custody. The reason, and let me give you the reasons for this too. We have these wonderful people and our alternates here who have taken the time out of their life, and we all know just come back from a small vacation or some kind of work trip, how we have to catch up and they have to catch up. And they've done things, and this is not the easiest decisions to make in the world. So I don't want anybody second guessing them. They've done an outstanding job. We all have to be proud of their accomplishments as citizens of Cook County. So again, what I want you to do is look into your heart. And if you can withstand the verdicts, please stay. But if you think you can't, I want you to leave, because there will be a zero tolerance at this time. Because I'm not going to have these people disrespected. And thank you, ma'am. I appreciate that. All right. And anybody else? All right. I know this isn't going to be easy, so I'm, asking you again to look into your heart. If you think you're not capable of this, then please leave, and we'll let you back in after the verdict. All right. We all ready? And I want to. All right. What I want to do too is we've had members from the media, both broadcast and press journalists. They've just been fantastic. Everybody's been really outstanding. The reporting on this has been very important because we need transparency, and especially a case like this. And I really want to compliment the media chairs. They've just been great. They've been very cooperative. We had a great session the other day with the two jurors, the alternate jurors that were excused, and we're allowed, to have the interview with them. I'm going to see if we can get another interview going with the rest of the jurors and with our wonderful alternates here. So again, thank you very much. I appreciate your interest. And again, thank you for the press. You've been outstanding. All right, bring the jury out, please.
All right, for the jury.
Okay, thank you. Will everybody please be seated? Will the foreperson please rise? Has the jury reached verdicts? Thank you very much. Could you give Jessica the jury verdict forms and just have a seat? Appreciate that. I like your jury. You're wearing them like necklaces. Fantastic. That's good. Ladies and gentlemen, let me explain certain things so you'll understand the verdicts a little bit better. All right. The charges in this case were first-degree murder, 16 counts of aggravated battery, and 1 count of official misconduct. There also, the defense had asked for the instructions in the jury verdict form on second-degree murder. All right. Let me explain the process here. Before anybody can get to second-degree murder, the state must prove each and every element of first-degree murder. There is no bypassing that and going directly to second-degree murder. As pointed out by one of our wonderful professors, Professor Kling, who's in the audience during his lectures, second-degree murder is a combination of first-degree murder plus a mitigating factor. It is not really technically a lesser included offense because it demands another set of proof, which would be the proof by the defense or the defendant going forward by preponderance of the evidence. So with this understanding, will you please read the verdicts?
We, the jury, find the defendant, Jason Van Dyke, guilty of second-degree murder. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, first shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, second shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, third shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, fourth shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, fifth shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 6 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 7 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 8 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 9 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 10 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 11 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 12 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 13 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 14 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 15 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 16 shots. We, the jury, find the defendant, Jason Van Dyke, not guilty of official misconduct.
At this time, Mr. Herbert.
Judge, we cannot hold the jury.
Can I have the attorneys over here for a second, please? Mr. Herbert.
Your Honor, this time we'd ask to hold the jury.
Ladies and gentlemen, I know this is, a new experience for you, but when anybody has been convicted of a criminal offense in the state of Illinois by a jury trial, the person that has been convicted has an absolute right to poll the jury. This was a remedy decided by our Illinois Supreme Court. And the purpose of this is in case somebody was forced to sign a jury verdict form in the jury room. And this gave that individual the opportunity to be in the public and say, no, this wasn't my verdict form. So it's an absolute right. So the question will be, was this then and is this now your verdict? Meaning, was that then in the jury room and is this now your verdict? So at this time, Tony?
Yes. Juror 240, were those then and are these now your verdicts? Juror 241, were those then and are these now your verdicts?
Yes.
Juror 242, were those then and are these now your verdicts?
Yes.
Juror 243, were those then and are these now your verdicts?
Yes.
Juror 244, were those then and are these now your verdicts?
Yes.
Juror 245, were those then and are these now your verdicts?
Yes.
Juror 246, were those then and are these now your verdicts?
Yes.
Juror 247, were those then and are these now your verdicts?
Yes.
Juror 248, were those then and are these now your verdicts?
Yes.
Juror 249, were those then and are these now your verdicts?
Yes.
Juror 250, were those then and are these now your verdicts?
Yes.
And juror 251, were those then and are these now your verdicts?
Yes.
Thank you.
Okay, John and Jessica, will you take our wonderful people of the jury and our 3 wonderful alternates back to the jury room, please?
All rise for the jury.
Ladies and gentlemen, will you please be seated? At this time, I'd like to express my appreciation for everybody who participated in this trial and also for the public that are here today. I know, depending on what side that you really favored, it wasn't easy for for this verdict to come in. And I appreciate what your restraint that you used today. It makes me very proud to be a citizen of the city of Chicago and also the county of Cook. So thank you. At this time, state.
Your Honor, at this time, the state would move to revoke defendant Jason Van Dyke's bond.
Mr. Herbert.
Judge, we would ask that the motion for the state to be denied. We would ask that in light of the fact that the client is not found guilty of first-degree murder, we would ask for a bond review. In the alternative, we would ask to come back next week for a bond.
Mr. McMahon.
Judge, I would object to that. The defendant's been convicted of 16 counts of aggravated battery with firearm. They're Class X felonies, mandatory minimum sentence of 6 years in the Illinois Department of Corrections, maximum of 30 years on each count. Given that he now stands before this court as a convicted felon, it has to be revoked his bond.
All right, bail will be revoked. All right, I'm going to order a pre-sentence investigation. All right, order court, October 31st, 2018. All right. All right, thank you very much. Appreciate that. Court in recess.
All rise.
Now you're going to set up.